Hello and welcome back to Law Logical, your weekly guide to decoding the laws of the land. If you've been following our series on the 18 stages of a civil suit under the Civil Procedure Code 1908, today's episode marks an essential phase in the process. In the last episode, we discussed the framing of issues. Today, we move to the sixth stage, plaintiff's evidence. This stage is the first opportunity for the plaintiff to substantiate their claims by presenting relevant evidence before the court. The stage of plaintiff's evidence, also known as examination of the plaintiff's witnesses, is governed by Order XVIII of the CPC. At this stage, the plaintiff is required to produce all evidence, whether oral or documentary, in support of the facts stated in the plaint. This evidence must directly address the issues framed by the court. There are two primary types of evidence the plaintiff can present: oral evidence, statements given by witnesses under oath; documentary evidence, written documents like contracts, receipts, or other records relevant to the case. These are further governed by the Indian Evidence Act, 1872, particularly Section 61, which emphasizes the need for evidence to be direct and admissible. The stage of plaintiff's evidence can be divided into three sub-steps. Filing of affidavit in evidence. Under Order XVIII, Rule 4, the plaintiff's witnesses must submit their testimony in the form of an affidavit. This affidavit serves as their examination in chief. Cross-examination by the defendant. The defendant has the right to cross-examine the plaintiff's witnesses to test their credibility and challenge the evidence presented. Re-examination. If required, the plaintiff's counsel can re-examine the witnesses to clarify any ambiguities raised during cross-examination. It's important to note that the plaintiff must adhere to the following rules. All evidence must be relevant to the issues framed. Under Order XVII, Rule 14, any document not filed with the plaint cannot be admitted later unless accompanied by an application explaining the delay. Failure to produce evidence at this stage can weaken the plaintiff's case significantly. Let's look at a real-life example. In the case of Raj Kapoor v. Nawal Kishore, AIR 1980 SC 605, the Supreme Court emphasized the importance of producing all necessary documents and witnesses at the earliest stages to avoid unnecessary delays in proceedings. Similarly, in KK Velusamy v. N. Palanisamy, 2011, the court reiterated that evidence must directly relate to the issues framed, ensuring a focused trial process. While the law is clear, practical challenges often arise. These include witnesses turning hostile, which can significantly weaken the case; difficulty in retrieving original documents, especially in long-pending disputes. In such situations, the plaintiff's counsel must be proactive and ensure thorough preparation before presenting evidence. In conclusion, the plaintiff's evidence stage is a cornerstone in any civil suit. It's the plaintiff's chance to prove their case and provide the foundation for a favorable judgment. In the next episode, we'll discuss the defendant's evidence, where the defendant presents their side of the story to counter the plaintiff's claims. Stay tuned. Don't forget to like, share, and subscribe to Law Logical for more insights into the laws that govern our land. Drop your thoughts and questions in the comments. We'd love to hear from you. Until next time, stay informed and stay legally aware.